TorahCafe.com.
Let's start with something from today's paper, from just a random newspaper, the New York Times. This is a quote from a story that ran this afternoon. Nearly 1 million poor people continue to be denied representation in the nation's courts because legal aid clinics lack sufficient financing, a federal-supported legal agency reported Tuesday. That's the quote. These challenging economic times, as I'm sure you've all seen, are particularly challenging for poorer people. It's they who disproportionately find themselves in the criminal justice system. And when that happens, even on what to folks with more money would be a modest charge, this can mean time in detention, awaiting trial, which can mean loss of a job or other workplace problem, which can lead to trouble making the rent, and which can lead to landlord-tenant problems, which can lead to the intervention of child services. And all of these things mean that a person needs the help not only of a criminal lawyer, but of a civil lawyer. And as the Times reports, money for that is in short supply. Judge Hayden, I think you've written on and ruled on cases that relate to this, have you not?
Well, yeah. I think that one of my passions, I don't think I know one of my passions, is the mass incarceration in our society. And you put your finger on one of the ways in which it starts, which is the arrest that doesn't lead to bail because of financial issues or a family situation that's so imperfect that the court is afraid to let the person out. For fear of flight or protection of the public. A record quickly gets made by particularly young men of color, that brands them, as it were, because computers quickly bring up a muddied past, and pretty soon they are in the system. Or you have people with language problems who can't make themselves understood. And you do not have in the court system, especially the overpopulated court system, any real way of figuring out what to do in a society that treats incarceration and detention as the response, as the proper response, as the sanctioned response to social nuisances. And a lot of the folks that are doing time or awaiting the opportunity not to do any more time are really more social nuisances. And the kind of crimes that you're talking about are those fairly minor charges, I'm assuming. You're not talking about crimes of violence, you're not talking about, so we're talking about the great swath. Yes. And we're throwing in some drug possessions as well. Once that person is in the system, it's very hard to extricate them. And I really don't have an answer for you. I say that I see it. I don't see it as a federal judge. We don't have that kind of volume. But we did, as state court judges, we do as state court judges. Okay, we do have that kind of problem as state court judges, and there are any number of responses. John can probably talk to how the state attempts to sift through these various levels of infraction. My point, and I'm sure I'll come back to it again, is that when the social nuisance, as opposed to the social threat, is treated the same way as the social threat, and that's what we do in our society. We are breaking the family ties, we are destroying the ability of people to come back into society, and we are creating what we have now, which is a society in which over 1 in every 100 adults is in prison, which is a statistic that puts us way at the top in the world of an incarcerative society. And I'm turning it over to John, but I may not.
Well, what I was curious about, Dean Farmer, is when you're training the next generation of lawyers, do you see them as having an ethical obligation to respond to this? If there's so many people unserved by the legal community, is there an ethical duty for a lawyer to respond?
No, absolutely there is, and you know, one of the strengths of Rutgers has been its clinical programs, which were developed in the wake of the riots of the 1960s, the first of their kind in the nation. And you know, this problem that you've identified really differs in extent from region to region in the country. There are some states that don't have a public defender system at all. New Jersey does. There are some states that whose law schools may not have clinics. New Jersey does. So I think it's less of a problem in New Jersey than elsewhere, but there's no question that as economic times get tight, the threat of the problem becoming serious grows. I mean, our law clinics have been funded by the New Jersey Bar Foundation for years very adequately, but that's dependent on the IOLTA money, which could drop. And if that drops, then the clinics don't get the money, then the people don't get representation. So hard economic times will only exacerbate whatever existing inequities exist in the society.
Rabbi, does the tradition of Talmudic law impose particular obligations to respond to the poor? I think we're talking about poor people here.
Absolutely. So I think here it's important to recognize that when we talk about charity, we in our modern society think about a checkbook and money. But the truth is that the Jewish tradition recognizes that the giving of one's time is the most important form of charity that a person can give. A lawyer can't spend all of his time working for clients who don't pay their bills, because obviously everybody's entitled to earn a living. But the recognition of the fact that when you have a skill, whether it's to practice medicine or to practice law or to make blankets, when you've accomplished what you need to accomplish to feed yourself and your family, it's incumbent upon you to give away some of your time and your effort and your product to those who need your product but can't afford it. Pro bono is a charity which is more important, or certainly no less important, than the giving of your money. And it's easy to think that when you talk about giving of your time, what you mean is giving it to a synagogue or some other event where you can act as a professional. But the truth is that when a lawyer represents a client in need pro bono, that's the most important activity that a lawyer can undertake, and a full-blown manifestation of the obligation to give charity to those who are in need. A great American Jewish law authority, Rabbi Moshe Feinstein, writes that it's appropriate for people to give 10% of their time to charity. And what he's talking about is a pro bono obligation on every professional. Of course, you as a lawyer could sweep floors in a hospital as a pro bono activity, but you're probably much better serving the society around you if you volunteer your time as a lawyer to engage in pro bono legal activities. The problems we've described would disappear. Forget about if every lawyer gave 10% of their time. I think the problems would disappear if every lawyer gave 5% of their time to pro bono clients. We'd have adequate representation for everybody. So I think you have to view it as charity. And just like you wouldn't turn away the rabbi when he asks you for a donation, so too you shouldn't turn away a client in reason if you have the time and you have the energy who's in need of legal representation. It's important not to think about charity as just money, but to recognize that it's time as well.
Well, all right, I'm the non-lawyer here, and I'm the least well-educated person in this room, I guarantee you. And so we believe that within the tradition of Jewish law, there's an obligation to act in these ways. We've learned that Rutgers is preparing its law students to see this as an ethical duty of all lawyers. We understand this problem is manifest in the courts. I haven't spoken to each of you individually, but clearly every single one of you is insanely virtuous, and yet, to quote from that rag, the New York Times, 1 million poor people continue to lack legal representation. Now my head hurts. How could that be? Obviously, this is all very nice in theory, but it's not working. So I put it to those of you on the floor, if any of you have something to say about this, or the panel. This is all very nice, but it didn't work. So what happens now?
I want to suggest a big answer, which is part of the problem is that people say when they confront a huge problem, like there are 1 million people, they don't say, well, I should do my one little bit. They instead say what we need is a systemic solution, and I bear no obligation to carry my little share. I think that part of the answer is that problems need to be localized and personalized so that even if you yourself can't represent all 1 million of these people, which you certainly can't, you yourself should undertake to represent one of them, and that you've done your fair share to the problem. No different than no one of us can solve the hunger problem in the United States, but that doesn't allow you to avoid the responsibility of feeding a hungry person who comes to you when you can.
I that, because I think it's a good point. In terms of a kernel of work that's being done in connection with Seton Hall Law School, and I think it's going to be picked up with Rutgers Camden at the south part of the state, is a consortium of practicing lawyers of years, law students, and here's the biggie, young practitioners who are able somehow between, I guess, 3 in the morning and 6 when they leave the firm and start up at the firm again, to attach themselves in this supportive environment and do wonderful things, like get licenses back for people who've served time and have like $80 million in tickets and can't drive and therefore can't get a job. Help with voting rights, help with getting child support orders straightened out. The very common and actually doable things that do not involve a court case, that involve sitting next to the person who would otherwise not know how to fumble through all of the red tape and white papers of an agency and get that person into the slipstream of maybe getting something done. And that is small, but that's directly affecting poor people, and above all, it's keeping the fire burning under those new lawyers before they lose what they have when they're in your institution and in Seton Hall.
Yeah, I mean, I think I don't know very many lawyers, if any for that matter, who would say that they don't recognize an obligation to do pro bono work. But I also understand that the practice of law is hard, and particularly as times get tough, and people's time, which is their most precious commodity, gets taken up, it becomes more and more difficult. And I think that accounts for the gap that you identified. I mean, it's not that the intention isn't there, it's that it's difficult in the practical world to follow that up with action.
I see. I'm assuming that you all have occasion to do pro bono work. If anyone wants to comment on that, we'd be happy to hear. Or if not, I'll name the names of the people who haven't done any this month.